Welcome back to One Stop Law. In a historic development, very recently, the Supreme Court on May 11th, 2022, has ordered that the 152-year-old sedition law under Section 124A of the Indian Penal Code should be effectively kept in abeyance till the Union government reconsiders the provision. In an interim order, the court has urged both the center and the state governments to refrain from registering any fresh FIRs under Section 124A of IPC while the provision is under reconsideration. Last Wednesday, a bench of the Supreme Court comprising of the Chief Justice of India N.V. Ramana, Justice Surya Kant and Justice Hima Kohli held that all pending trials, appeals and proceedings with respect to charges framed under Section 124A of IPC be kept in abeyance. Adjudication with respect to other sections may proceed with no prejudice to be caused to the accused. The bench also said in its order, and I quote the bench here: "We hope and expect centre and state governments will refrain from registering any FIR, continuing investigation or taking coercive steps under Section 124A IPC when it is under reconsideration. It will be appropriate not to use this provision of law till further examination is over." Now, it is not the first time that the Supreme Court of India has expressed its concern over the continuance of this draconian law. So, before I delve directly into the matter concerning this particular case, let me give you a brief introduction to the meaning and origin of the sedition law in India. Let's get started with the video. Now, what exactly is sedition? Sedition is actually made an offence under the Indian Penal Code under Section 124A, and it is penalized there. Section 124A defines sedition as an act where whoever by words, either spoken or written, or by signs, or by visible representation or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law, is said to commit sedition. The provision also contains three explanations. First explanation states that disaffection includes disloyalty and all feelings of enmity. It also says that expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offence under this section. This is explanation 2. And the third explanation says that comments expressing disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offence under this section. Now, the offence of sedition is penalized under Section 124A with a punishment of imprisonment which may extend from 3 years to lifetime imprisonment along with fine. Now, if we look at the origin and the evolution of the law of sedition in India, we find that, like many laws which have been enacted in India by the British because they were our predecessors, Indian Penal Code is also a law which was enacted by the British. And this sedition section was introduced in IPC in the year 1870 by the British only. Now, the provision was extensively used to curb the political dissent during the independence movement. Several pre-independence cases involving sedition under Section 124A IPC were registered against our celebrated freedom fighters, including Bal Gangadhar Tilak, Annie Besant, Muhammad Ali, Maulana Azad, and Mahatma Gandhi. It was during this time that most notable trials on sedition were witnessed by India. The first case and the first trial in India on sedition was against Bal Gangadhar Tilak, and the case was named Queen Empress versus Bal Gangadhar Tilak in the year 1898. So we see that the British had introduced this law only to curb our freedom fighters, not to protest against the British government and not to go against the British government. But then what happened after independence? After independence, first of all, we saw that our Constituent Assembly was not at all in favor of keeping this law or this word in our constitution. So in 1948, there were deliberate discussions where the Indian leaders agreed to drop sedition from the Constitution of India. In 1949, it was the situation was that sedition was no longer a part of Indian Constitution, which was adopted on 26th of November 1949. However, it was kept as an offence under the IPC. Section 124A IPC was retained by the Indian government. In 1951, the then Prime Minister, our first Prime Minister of India, Jawaharlal Nehru, brought the first amendment to Article 19(1)A. Article 19 provides for basic individual freedoms to the citizens of India, and Article 19(1) provides for 1A gives us the freedom of speech and expression. And he added under his government the term reasonable restrictions were introduced under the and in form of Article 19 clause 2, which basically given said that freedom of expression does not allow us to go on and create public disturbance by our hate speech. So basically reasonable restriction in this case was introduced as to bring public order, morality, and as a restriction, as a limitation on freedom of speech and expression. Then in 1974, Mrs. Indira Gandhi government and her government made Section 124A a cognizable offence that authorized police to make arrests without warrant. And if you look at the present situation, what we see that in comparison to the number of cases lodged under this section, under the law of sedition, the rate of conviction is very, very low. And specifically after 2014, it has been noticed, it is not beyond the notice of the Supreme Court as well, that the number of cases being registered and lodged under this section have increased many times in number. The 2019 data shows that sedition cases rose by 25% after 2014 and arrests by 41%. But then only 3% of the cases have led to convictions. So this is the situation of the sedition law right from the beginning and the situation till now. Now, this is not the first time that the Supreme Court has expressed its concern or it has raised question on the viability of this law. Many a times, Supreme Court has raised its doubt regarding the point of keeping this section in our IPC, because the court and many experts, they feel that this section was particularly enacted by the British for their own benefit to curb the freedom fighters from going against the British government in India. So the court has time again raised this question. The court has to quote, if I quote the court in this context, we can see Supreme Court has previously said that the enormous power of misuse of this section can be compared with a carpenter with a saw, who instead of cutting a tree cuts the entire forest. So the court also has observed that there is no dispute that it is a colonial law and was used by the British to suppress freedom of India and was used against freedom fighters like Mahatma Gandhi. So even after so many years, 75 years of independence, what is the necessity of keeping this law in our Indian Penal Code? Another very recent case where the Supreme Court criticized this section 124A of IPC and its misuse was when an FIR was registered against a veteran journalist of India, Mr. Vinod Dua, for criticizing the government's actions, basically the government's inability in controlling the COVID pandemic in his YouTube channel. And the Supreme Court not only quashed that FIR, it said very clearly that every journalist has a right to criticize the government and that a citizen has a right to criticize or comment upon the measures undertaken by the government and its functionaries, so long as he does not incite people to violence against the government or with the intention of creating public disorder. So the Supreme Court very clearly said that every citizen of India has a right to dissent, to not to agree to government measures, and has a right to fairly criticize it without inciting hatred amongst the people. Now coming to the most recent historic judgment of the Supreme Court on this sedition law, which came on 11th May 2022. Just to give you a brief history and context of the case, the court had first heard a batch of petitions in July 2021, where the principal line of challenge was that the earlier judgment of the Supreme Court in Kedarnath versus State of Bihar case of 1962, where the validity of section 124A IPC was upheld, and it was held that it was completely good in law. This batch of petitions actually challenged that this was not good law anymore. The central government then was asked to file its response to the petitions. It failed to do so in proper time. It was first asked to submit its response by April, then the time was extended to May. Ultimately, in the month of May, the central government gave its opinion, although the government initially tried to defend the colonial provision, but later on it agreed with the apex court and said that okay, it will be reviewing it. Now, after hearing all the parties, the petitioners, the central government, the Attorney General, and the Solicitor General, the three-judge bench on May 11th, 2022, held that after observing that the Union government stand that the colonial provision requires reconsideration and re-examination means that the government has agreed with the prima facie view expressed by the court that the rigors of Section 124A IPC is not in tune with the current social milieu and was intended for when the country was under the colonial regime. Therefore, the court has ordered the Union Government of India to reconsider the provision. If I quote Chief Justice Ramanna here, he said that the court is cognizant of the duty of the state on one hand and the citizens' liberties on the other. There is a requirement of balance of consideration. The case of petitioner is that this provision of law dated back 1898 and is being misused. The Attorney General have also given instances of glaring misuse of like cases. Therefore, and I quote the three-judge bench, therefore we expect that till the re-examination of the provision is complete, it will be appropriate not to continue the usage of the aforesaid provision of law by the governments. The court has also held that those already booked under Section 124A IPC and who are in jail can approach the concerned courts for bail. It has also been ruled that if any fresh case is registered, then appropriate parties are at liberty to approach courts for appropriate relief, and the courts are requested to examine the relief sought, taking into account the order passed by the court. These directions will be in force until further orders. So, this is all about the update on the recent sedition law under Section 124A IPC and the Supreme Court's historic verdict on it. Let's see what re-examination and what suggestions the central government comes up after reviewing the law, and this draconian law needs to be changed and amended according to the present social scenario, and not it should not stay at in the state as it is, because it was completely architected by the British to to dominate and to suppress our freedom fighters. So that's all for this video. I will see you in some other video on some interesting topic. Till then, thank you all.